We try to get everything set up so that you can be comfortable. That the fact that you've got everything set up to make it as easy as possible. What I hear constantly from my clients is that the reason they're doing an estate plan is they want to, as far as possible, make it easy on their survivors, on their heirs, on their kids, on the persons that are, end up inheriting their property. And I think that's really a good goal. And it's not super easy to get accomplished, but it is definitely possible. It just takes a little bit of time, a little bit of effort, not a lot, but enough to get things organized. And you can organize in all different levels, whether it's going to be you just have a will, or you have a simple straight through trust, or maybe you have a trust that splits on the first death, or you can have trusts that kind of take different shape as you go along, depending on your conditions in your life. So it can be anything from a fairly simple trust all the way to very complicated, fancy estate plan, multiple trusts getting triggered by certain life events. All those things can happen in your estate plan. What I always tell people, and I really think it's good advice, not just because I give it, because I've heard it before, is if you have nothing in place, then something is better than what you've got, because the California law does a terrible job at getting your assets to your kids or to your beneficiaries in an orderly fashion. It does a bad job, even if husband and wife have always been married to each other and they have all their children are their common children and none of their children have children. I mean, and they're all over 30. I mean, it's like the conditions under which you could default under California law and really get accomplished what most people want to get accomplished. The conditions are really just not there. It's just under very limited circumstances. So most families, literally, I can say that a majority of families now in California are blended families. That means all the children are not from the same two parents. And a majority of families, the mom and dad, the husband and wife that are married now, are not the same as they were for at least one of the other children. So there's going to be steps. There's going to be, stepkids, maybe adopting stepchildren. There's going to be issues with prior spouses, either deceased prior spouses, which happens. Divorced prior spouses happens in about 60 to 70% of the time in California. So there's just a lot of reasons for you to do the planning yourself. And I am trying to make that as easy as possible with this show. I want to start out backwards, though. Let's talk about a seminar that I do and just did one just very recently called, basically what happens after someone dies. Okay, so we're just going to go through that. If you have questions for me, please feel free to call 888-344-1170. That'll get you through to the on-air line. You can be on air with me today. You can ask me your question. I'm just going to ask for your first name. And I don't need any more information, but I just want to see if you have questions for me. It's 888-344-1170, as always. And if you want directly to talk to me to schedule some time to get your free initial consultation, that number is 855-500-TRUST. All right. So the first thing, let's say, okay, you pass away and you have no will, no trust or anything. Because you're no longer here, we now need somebody to act for you, right? So you own a house, the house is in your name, and let's just say it's, we'll just say it's Ted. So Ted, it's your house, your name is on it, the title, and you die. How does Ted transfer the house? Ted's dead. Ted can't sign anything. We know that. I know Google's working on technology to change that, but bottom line is Ted can't sign, so Ted can't sell the property. If Ted doesn't have a trust or anybody assigned to do the work, to do the transfer for him, somebody has got to go to court, and that is in probate court. Probate court is the division of the California Superior Court that deals with people that are either incapacitated or dead. Somebody's going to have to petition the court to become the administrator or personal representative of the estate. They're going to be representing Ted as his personal representative. And that personal representative will get the authority from a court after petitioning in about 2-month process. They'll get permission or authority to sign Ted's name to sell property or sell assets. And not to distribute them, but to put them into a specific bank account in the name of Ted's estate with a tax ID number that is going to be obtained for Ted's estate. And there's where the money will stay.
2 minutes.
And the property until Ted can get the whole thing through the trust or the probate process. All right. So that's just the basics. That somebody had to step up because Ted didn't name somebody. How often does it happen? Well, if there's nobody, who are his beneficiaries? Does he have children? Does he have a brother and sister? Who's going to ultimately get his property? That's going to be the person that's usually going to step up, the one that's going to benefit from stepping up and being the personal representative. Okay. So that's if there's no will. If there is a will, that same thing is going to happen, except the will have named who Ted wants to be the personal representative. So that's going to be maybe a child, or maybe it's going to be a brother or sister or an uncle or aunt or something. But at least we'll know when Ted dies, we'll know by looking at his will, who's the one that he wants to have take his will to probate court and do the probate thing. Okay. If Ted was better planned and did a living trust, then we're just going to look at his living trust. And in that trust document, it's going to name someone to act as his successor trustee. Okay. So the successor trustee, you're going to have maybe 3 people in a row. He's going to say, okay, I want my brother to do it. And if my brother doesn't do it, then I want somebody else to do it. You could, usually I like to have people name like 3 people, just in case 2 of them can't do it, then at least you have the third. And that way you don't have to amend the trust so soon. But there's going to be somebody that's going to have to step up and be the successor trustee. And that's the person that's going to be able to sign the title to the assets to transfer them to wherever they're going to go. Okay. So I want to talk about that process more. Like specifically, what does that mean when I say somebody's going to step up and act as the successor trustee? Some of you are in the process of doing that, or are soon going to be doing that, or maybe you did it in the past and you want to know kind of how that process works. That's what we're going to be going through step by step coming up next here on the Word on Wealth. Again, if you've got questions, it's 855-500-TRUST. Call me and get your appointment. Let's talk about it.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is faith-based investing with Anthony Wright.
Most Christians just don't understand that the money they save for retirement usually helps fund the abortion industry and other liberal anti-family causes. But did you know that with just a few minutes of your time, we can screen and clean your investments at no cost to you? It's absolutely complimentary. Just go to the website right now, download a free copy of my book, Faith-Based Investing. It's free as well. You deserve to know the truth as the investor. Then the choice is yours. You can keep doing what you're doing, or you can line up your investments and life savings with your beliefs. We are fiduciary investment advisors. You can feel good about investing with confidence. So learn more now. Go to BibleSafeInvesting.com or call me at 931-RETIRED. Your free book is waiting for you. Go to BibleSafeInvesting.com and be sure that you listen to Faith-Based Investing this weekend right here on Family Car.
Gary, your team at GQ Law are experts at solving IRS and state tax problems. Talk about that.
When people have a tax problem, it tends to really stress them out. And one of the things we've been able to do is figure out how to resolve tax problems. One thing we might be doing is setting up a payment plan or getting a collection delay, maybe getting a determination that the person shouldn't have to pay the taxes at all. We do offers and compromise. We do auto reconsiderations. And one of the things that's a really powerful tool that some people don't recognize is sometimes bankruptcy can be used to actually eliminate taxes when there's certain conditions of the code that are met. So we can do all kinds of things. After we analyze your situation, we can figure out what's available, discuss your options, and figure out which ones to implement, what it's going to cost, how long it's going to take. And we can get people out from under all kinds of tax problems so they can sleep again. That's our goal.
Request your free initial consultation. GQlaw.com. 855-500-TRUST. GQlaw.com.
Who will you trust with the biggest financial decision of your lifetime? If you're planning to buy or sell a home in San Diego County, do what I do and work with the true San Diego real estate experts. Ken Pecos and the Pecos Group helped me and my family. They can help you. This is Gary Quackenbush of The Word on Wealth. You hear Ken every week here on The Word on Wealth. He's our expert. He's got integrity, exceptional service, deep knowledge of the San Diego, Coronado, and South Bay regions. These are just some of the reasons that Ken Pecos has completed hundreds of transactions. He manages a powerful team of professionals at the Pecos Group. From single-family attached homes to luxury high-value waterfront properties to apartment buildings, Ken Pecos is ready to help you avoid problems and costly mistakes. Learn more online at kenpecos.com. That's Ken Pecos, Pecus.com. Or call 619-977-8419.
DRE number 010566969, brokered by eXp Realty.
Dennis Prager here. Say goodbye.
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, gqlaw.com.
You're live. Hello. All right. Let's talk about, we're talking about trust administration. All right, folks, here we go. Okay. We've been talking to start out at the beginning of this thing. We're talking about, okay, what happens if you pass away? Who's in charge? Who gets to take care of your things? Have you ever wondered how that works? That's what we're answering here. If you want to be on the show with me and ask me the question in particular, I can answer it. Hope so. If you stump me, that'd be wild. 888-344-1170 is the number. And if any of this kind of pricks your interest and you go, whoa, that applies to me, of course, you can call me and get your free initial consultation. Mention that you're a listener and that you heard this show. And that number is 855-500-TRUST, 855-500-TRUST. The reason you want to know this stuff is because if you are a beneficiary because mom and dad passed away or uncle passed away, and you know you're a beneficiary because you heard you were, or maybe you've seen a document that said you were, if what I'm talking about is not happening yet, and you know you're a beneficiary, then you're going to know what you should have received and what information you should be getting regarding your potential or future inheritance. Okay. If on the other side of things, if you are a successor trustee, because maybe Uncle John passed away and he named you, his trusted person, to be his successor trustee, then you're going to want to know what your job is. Keep in mind, if you are a successor trustee, your job is to act as if you were a professional, like you really knew what you're doing, because the law is not super forgiving. If you have stepped up to do the job, like let's say your uncle named you as the successor trustee of his trust, and you decide to, step up and do it, that's terrific. That's what he wanted. Keep in mind, though, that you have to do the job right, or you have to hire the right professionals to help you do the job right. When you are a successor trustee, there isn't any legal excuse for not doing it right. Does that make sense? Because if you say, well, I didn't know any better, that's everybody's excuse, because everybody that's a successor trustee, and this is almost universal, if you are acting as a successor trustee, you probably have never done it before. Now, I have met a few people in my career that have done it before. They're currently serving as a successor trustee for a parent or a grandparent, and they understand the process. But most of us, when you get asked to be a successor trustee, you don't know what you're doing because you've never done it before. And you could watch all kinds of YouTube videos and you're not going to find anything out anyway, because this stuff's too important. You can talk to all kinds of people that have done it in the past, and maybe you'll learn some of your jobs. But what happens is if you want to do the job right and you don't know how to do it, you don't just jump out of the way and say, forget it, I'm not going to do it. You hire people that can help you do your job right. Because the way the rules work is if you are performing a task and you are incompetent, like incapable of doing it properly and legally, that's only okay if you did something to kind of get rid of that incompetence. What I mean is, if you hire someone to help you do it and they can teach you the right way to do it, you can still act as the successor trustee, though you've never done it before. And this counselor, coach, attorney, tax professional, these people that are helping you do it right, they're the ones that are coaching you and telling you how to do it right. Therefore, you become competent because you've got the right professionals helping you figure out what needs to be done. Okay. So that's the fiduciary duty thing. You need to act as if you knew what you were doing and perform all the tasks that you didn't know you're supposed to do, but you're still going to be legally obligated to do them. So here's some of them. And this is just like basically 10 of them. We have a list of about, I think it's 28 steps to close a trust properly if you're the successor trustee, but don't have time to go through 28. So let's just go through through 10. These are more general, not any little sub steps. Okay. So when someone passes away, and in this case, it's Uncle Ted, he passes away, he names you as the successor trustee. Your job is to step up and say, okay, I will do it because he's asked me to. And you are to notify all of the beneficiaries of the terms of the trust. Okay. All the beneficiaries and others who are entitled to notice, entitled to get the notifications. So we know that's going to be any of the kids in the trust, because if there's children and if there's only one named because the other ones are being disinherited, all the children still, because they're direct heirs, they're going to get a copy of the terms of the trust. If they do not get the terms of the trust and you distribute all the money to the one beneficiary that's named as the, as the one getting everything, that's a violation of your fiduciary duty. You have to give notification to all of the beneficiaries. And the notification is a very formal notification. You can find it in the probate code. It has to be written in 12-point font, right? What does that mean? It's pretty big font, and it has to say specifically certain things about what you're doing. That it has to say that California law gives them the right to know the terms of the trust, and that you're providing the terms of the trust, that they have a right to request a copy of the trust, and that once they actually get their hands on a copy of the trust, then they've got 60 additional days or 120 days from the day they were first notified, whatever's longer. So they can have 120 days, they could have 180 days, depending on when they received the actual terms of the trust and the actual copy. What you do then is you send out a copy, an actual copy of the original, not a copy of a copy or a copy of a copy of a copy. An actual copy of the original goes to all the beneficiaries. It's going to be all the kids. Anybody whose name is in the trust is going to get a copy, because that's part of the legal requirements. Okay. And if they're heirs, you're going to have to go out to heirs also. And that depends on exactly what's going on and if all the kids are alive and that type of thing. Okay. So everybody gets notification. And if you can't find somebody, we've talked about that in prior shows a couple of times. If you can't find anybody, well, too bad. You have to find everybody. That means you're going to have to hire a private investigator. If you can't find somebody in particular, get a private investigator to go find them. You either have to prove that they do not exist, i.e. they've passed away, or you have to find them. And sometimes that's a delay of months or even years to try to scratch somebody out of the ground and figure, or, to try to scratch through records to try to find somebody. And you're going to maybe have to hire a private investigator to do that. Okay, so that's step one, formally notify all beneficiaries of the terms of the trust. Number two is creditors. the decedent's creditors, the guy who died, his creditors or her creditors are entitled to receive notification. So what you do is if you have any paperwork at all that indicates there's a creditor or creditors, those creditors are legally entitled to get notification. Hey, Uncle Ted died. Does he owe you any money? Because I see a bill here for $164. Does he owe you any money? If he does, make a claim and prove it. And they have to prove it. They can't just say, oh yeah. So here's a text message from him saying I owe money or he owes me money. It's going to be, they have to have proof. So what I do also is we notify creditors by a listing. So we actually go and do newspaper posts, and there's a specific way you have to do it. But we do a newspaper post that basically says, hey, this guy died. If you're his creditor, you've got 4 months to come forward and get information to my office, and they have to get it done by a certain date, or else they will be barred from collecting any money. So if the creditor is not known, that might be a potential lawsuit or some issues that's hanging out there, or a debt you didn't know they had. Those are things that are going to be wiped out by the creditor notification. And then we have to sometimes argue with the creditor, but they get notice, they got a time to reply. It's not very long. And that's how you cut off some of these claims that might be in existence. Okay. Number 3 is you have to notify the Department of Health Services. They are entitled to notification that a person has died so that they can then look in their records to see if that particular person received any benefit, any financial benefit, any premium subsidies, any money or credits from the Department of Health Services, which would be typically Medi-Cal. And Medi-Cal sometimes is tied to the Obamacare thing that came into play, 8 years ago. So sometimes there's some tie-ins to that. And so some estates will have money owed to the Department of Health Services. And sometimes it's arguable whether that money is really owed, but the Department of Health Services will send a claim. Why is this important? Because you're the trustee. And if you're the trustee and you don't notify the Department of Health Services and you give everybody the money they're entitled to, then Department of Health Services comes back and they say, hey, we notified you that there's a $13,000 bill. Where's the money? Well, if you have already given out the money to the beneficiaries, you cannot go back to the beneficiaries and say, oops, guys, there's a $13,000 bill for medical payments subsidized under Medi-Cal. So I need you guys to each return some of that money I gave you. They don't have to. They can all just say, forget it. We're not going to give you any money back. Pay for it out of your own share, because that's legally what you have to do. You have to cover that because that's an error. So that's why we notified the Department of Health Services. Don't make that mistake. Okay, the fourth thing, and this is the biggest one, is your job is to prepare and get an accounting of all of the trust assets and get approval either from a court, either in probate court, get an approval of the accounting, or get all the beneficiaries to agree. So what you do if you become the successor trustee, as soon as you figure out that you're it and you accept that job, that responsibility, you get a tax ID number. You go immediately to the bank and set up an account in the name of the trust with a new tax ID number. And every penny that you get or find gets deposited in that account. Now, if there's stuff like household goods or things that you think, you don't want to sell them, you just want to give them to a beneficiary, fine. But any money is going to go into this new account. It's going to be the administrative trust account. And that's where all the money is going to go. If you don't do that, then what's going on? How do you do an accounting if everything is in all the old accounts and he's got, accounts at San Diego County Credit Union and Wells Fargo and Chase and Union Bank and Home Savings and all these banks that don't even exist. I mean, it's like, what are you going to do? It's just, you got to gather them all together, put them all in one account so that they can be accounted for. So keep track of every penny. Don't make that mistake and say, oh, I didn't know that.
1 minute.
Let me go back and kind of revisit my records and see what I spent. You're going to get in trouble doing that. So as soon as you take the reins, as soon as you act as successor trustee, you've got to start keeping track of the information and put files together. Like if you have a Wells Fargo statement, open a new Wells Fargo folder. If you all of a sudden get a San Diego County Credit Union account, then open a San Diego County Credit Union account folder. So you can just start sorting the mail by, where it came, the institution. It makes it so much easier, because if you stay organized from the beginning, It's not going to be this big pile that you say, I'm going to get to it. I'm going to get to it. And then when you need to get to it in 6 months from now or 2 months from now, because somebody's screaming at you, it's going to be a big headache. So get going on it early, do your job right. The next thing I want to go over, and I am going to get through this, is figuring out exactly what your job is as the successor trustee, or what you can expect that your trustee is supposed to be doing. Your mom and dad's trustee, where you're going to get some money. That's what we're looking at here on the Word on Wealth. Call me 855-500-TRUST. And through the rest of the show, we're going to be talking about what are the other jobs of that trustee, coming up next year on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST. Ask for the legal help you need. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-500-TRUST.
So good to have you along. All right. We are we're actually doing it. We're figuring out what a trustee's job is. So we're saying that Uncle Ted has passed away, and you know that you're his beneficiary because he told you so, or maybe you even saw a document to that effect. And we're talking about exactly what needs to be done, because if you don't know what's supposed to be done, then you don't know what to expect. I mean, I've talked to a lot of people where, I was told that I was a beneficiary and I haven't heard anything. It's been, a year, it's been 2 years, and I'm just getting nervous. I don't know what's going on. Did I miss something? Did I miss a deadline? And if it's been that long, that's a long time. It may not be too late, but you gotta kind of be on top of things. And I think part of what people are afraid of is that if you think you're a beneficiary, but you're not really sure, then you think that you're being selfish or something, that you're wanting to know what's going on. It's like, am I trying to kind of jump in and say, hey, did the uncle leave us any money? But if uncle said he was going to, then yeah, you have the right to look into that and figure that out. If it's your parents that have passed away and now you have a sibling, your brother or sister that's working on the trust administration and you haven't heard anything in like 6 months, that's really too long to wait. You shouldn't be waiting that long. You should be finding out. And you don't need to run out and get a lawyer right away unless you're nervous about it, because if it's been 6 months, I think that's too long. I really think that you need to have known what's going on, because here's the thing, and we just talked about that. Within 60 days of the date of death, that successor trustee who's doing the job, within 60 days, they're supposed to send you the terms of the trust. Okay. So if it's been more than 60 days and you don't know what the terms of the trust are, that's a violation of the trustee's duty and responsibility to you as a beneficiary. By the same token, remember, if you are a successor trustee and you just don't know what to do, you just know you're the trustee and everything goes to you maybe, or you and your sister, and you haven't done anything, you got to get on it. Okay. Now, it doesn't mean it's not a crime if you don't. It's just a violation of what your job is as the successor trustee. Your job under the California Probate Code is, when somebody passes away and you are the trustee, it is your job to get notification out to all the beneficiaries within 60 days of the date of death. And if you don't do that, that's kind of strike one against you. If you then, if you don't go and file the will with the probate court, which everybody's required to do, if there is a will, you file it with the probate court. So if there is a will and you didn't do that, that's strike one or strike two. And then the other thing is, what if a beneficiary says, hey, I want to know what's going on. I want an accounting. They don't have to ask even that formally. Is I want to know what's going on. I want to know what money is where and who gets what. I want to know what that is. And that's going to be an accounting. If somebody has insisted on getting an accounting or demanded or requested an accounting, you've got 60 days to give them that accounting, or come up with some terrific excuse and tell the courts that you need more time, or try to get more time from that, the beneficiary, the sibling or whatever. But you've got to do it within 60 days of the demand. And if you don't, so let's just assume you didn't deposit the will, you didn't do the notification, you haven't done an accounting, and it's just like, you don't know what to do. I mean, you're working really hard, you got stuff going on. It's just like, there's a lot of confusion. You're not sure what is in the trust or whatever. If you don't do anything, you're going to have these suspicions getting higher and higher and higher. And eventually somebody is going to rightfully go to the probate court and say, hey, judge, I've asked for an accounting, I didn't get it. I've asked for a copy of the terms of trust, I didn't get it. I don't see any notifications. I don't see any publication in the newspaper. I don't see any deposit of the will. I want that person to be removed as the successor trustee and let me do it. And that happens sometimes if the next successor trustee in line is like another sibling, like a brother or sister, and they're waiting for you to do your job and you haven't done it. There's a good chance they're going to go to court to try to get you kicked out. And a judge will look at it and they're going to want to do something about it, because they don't want money that's in the hands of someone else because the decedent died and now the money is in your hands as the trustee, or your brother's hands as the trustee. The court wants that stuff to move along. Either that, or they're just afraid things are going to just disappear, which is a bad thing, especially when you're dealing with a judge. All right. So watch out for these things. Now, if there's money that was invested, let's say dad passes away, he leaves you an investment account with $20,000 in it. Well, if that's now in the hands of the successor trustee, which it should be, and there's going to be some delay in in getting that money to the beneficiaries, which there may not be, but that money is supposed to be guarded, meaning they can't put it in some harebrained, let's go put it all in cryptocurrency and see if it grows. That's way, 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 way too risky. Instead, they put it in something like a savings account or a T-bill account, and it may or may not earn a lot of money. Like nowadays, it would earn pretty good money, but not really good compared to like real investment money. But at least you can put it in something that will earn money. That's what you're supposed to be doing to try to at least keep it from going backwards too fast because of inflation. But you got to invest and manage assets. And if there's money that needs to be invested, like it's a brokerage account or something like that, you are not allowed to do that investing unless you are a broker, unless you do it professionally. You're not allowed to do it because you've got to get professional guidance so that it can be put in the appropriate account at the appropriate risk level. So that's the investing and manage assets as a fiduciary. Fiduciaries do what is right for the client, what is best for the client, not for what the client actually, not necessarily for what the client wants. Okay. The next thing you do as a successor trustee is you pay for the health, education, and maintenance of minor beneficiaries if that's required in the trust. The way that would work is you may have, maybe when mom and dad passed away, you have a younger brother that's only 14, and that money, his or her share, is sitting in that trust, and the trust allows that child of theirs, maybe your brother, to get money for health, education, and maintenance. And it's your job now to determine what's fair and what should happen. So if the beneficiary is making a lot of money and they don't really need anything, or they're exaggerating their health costs, you can agree to pay the bill directly. You don't have to hand them money. If they say, oh yeah, I've got a $6,000 health bill, don't hand them $6,000. Get the bill, check the bill, and then pay it. But you're going to be the successor trustee. You're going to have the right to look at the bill, and you're accounting for all of that money. Now, that's beneficiaries that are considered minor or incompetent. Incompetent would be like, let's say parents designated that you couldn't have money until you're 25. That doesn't mean you're like incompetent, like dumb. It just means incompetent, like legally incompetent. You can't make legally binding decisions until you're 18, unless it's for like basic necessities like health and food and stuff. Okay, so you're going to be paying for the education, maintenance of minor beneficiaries. So that's going to be a big job. Trustee, if you're selecting your successor trustee, make sure they know, that they're going to step up for that. Okay, other big tasks. The big and boring things is you've got to get tax returns done. I mean, yeah, mom and dad passed away, but they still are, they still might have taxes due, like their own tax returns that weren't done by the end of the year. Those have got to be filed, and the person that's responsible is, you guessed it, that is you as the successor trustee. Your job is to then do what is right for them and get the tax return information into your tax professional. Don't do it yourself. I don't care if you've done it before. Get it to the tax professional so they can do it at a fiduciary level. Okay. So once you, I think that's one of the big things, in my opinion, is that you have to be able to get the returns done on a timely basis. Because what happens if you're late or you mess it up and there's like some late fees or something? Well, if there's late fees, then the successor trustee, it's their fault, and they're probably going to end up having to pay the late fees out of their own share, which seems totally unfair. But the successor trustee's job is to do it right. And if they didn't do it right, then they're going to have to pay the penalties. So you can already see being a successor trustee is a big deal, big job. It's not something to take lightly, either as the nominated successor trustee, or when you're nominating one in your own trust. Make sure that they are going to be able to step up to the plate. Okay. The other thing is, now for the successor trustee, is the stuff that's more exciting. And that is, you've already prepared the accounting. Everybody's approved the accounting. They say, yeah, we're okay with what was done and what was spent and how much is being paid to the trustee and the attorney and all that stuff. And then next comes the beneficiaries getting their stuff. So that's the exciting part. That's what we're going to be talking about coming up next, is what about the distribution? How does that work? And I'll tell you briefly how it works. And then what we really, really want to do as the trustee is you want to be done with your job and be released from that responsibility so you can just move on with your life and not keep worrying. All right. So distribution of assets is going to be the change of title. If you're getting a house, it's going to be change of title on the house, the preparation of the forms that go along with that. That's all. You got it. Trustees' duties. Well, you don't know how to prepare a deed, or you don't know how to do a preliminary change of ownership report for the county assessor. That's all stuff that you're going to delegate out. Successor trustee, you've got to get people on your team, a good attorney, a good tax professional, a good accountant, get all those people on your team to help you out. You're listening to The Word on Wealth, and we're talking about closing up a trust and being a good successor trustee. And coming up next, I want to finish it up and say, how do you wrap up the trust? It's a good thing to know here on The Word on Wealth.
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
Gary, how do you and your team help our listeners avoid probate?
Well, first of all, probate is a process that involves attorneys, judges, and investing parties. And so we try to avoid probate at pretty much all costs. The way we do that is setting up living trusts, setting up properly documented wills, putting the property like houses, cars, bank accounts in that trust so that it avoids probate. Probate is only necessary if the estate plan isn't set up quite right. So we help them get it set up right. And mainly that's done through a properly created living trust.
Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free initial consultation. That's gqlaw.com, 855-500-TRUST.
This is Dennis Prager. Now you can listen to my show when it's convenient and without. Listen to the show on demand when it's easiest for you. This includes every radio show, every
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQlaw.com.
Hey, whoa. I seem to have lost my voice over the weekend. I wasn't screaming or anything, I promise. But here we are. We're finishing up. We are definitely finishing up. What we want to make sure that we have done by the end of the show is we want to make sure that we know exactly what the trustee is supposed to do. Because your job, if you think about this, as the successor trustee, what is your biggest desire? The biggest desire is to be done with your job, is to not have to do it anymore. You want to be done, and I mean literally done with your job. You don't want to have anything hanging over your head. I talk to people quite regularly who have been the trustee of their family's trust for like 2 or 3 years. And I want to talk to them about, well, how did it go? And what did you do? And have you done an accounting? And they say, yeah, everything's distributed and everybody seems to be really happy. Everybody's good with the money they got, but I got a notice the other day from the IRS and I don't understand what that means. Or, yeah, I got a call from my brother and he wants to know what happened to the money, or he didn't think he got the right amount. And thanks for doing your job, sis, but you know, where's the rest of the money? And a beneficiary can require an accounting. And whether it's a simple accounting or a complex accounting, it doesn't really matter. They can get either one. And so at a minimum, you need to prepare an accounting, whether it's a simple, not super detailed, but just a overall, here's what money existed, here's the account it was in, here's how it was spent, and here's the balances that get distributed. You have to have the beneficiaries agree to it. Because if you're just handing out money and saying, I think I did it right, trust me, you know, here's my Excel spreadsheet, that's really, in my opinion, not good enough. You want to be released from your job as the trustee eventually. So if it were me, I would be putting together an accounting and I'd be putting together a report to the beneficiaries and saying, here's where all the money went and here's where it all is. And here's how much money each of us get. And I want them to look at it and study it and ask questions. And then when they all agree, that looks good, that's, that's perfect, it's good enough for me, or whatever, they all agree that it's okay. Then they each sign a document saying that what they're receiving is all that they're expecting to receive. And we call that the receipt. And they give you the receipt and they get their check for whatever the distribution is. They may be getting a title to a piece of property and a check, or just a check, but whatever has been arranged and settled, everybody's agreeing to it. Because once the checks are issued and all that's dispersed, and you're going to save, you're going to hold back some. And sometimes we say you're going to hold back, I don't know, sometimes it's 10,000, sometimes it's $500,000, depending on the size of the estate. And that money's being held aside so that if there's any other issues that come up to pay taxes when the taxes are filed later, or if there's any issue with the IRS is questioning and we need some money to resolve it, or there's an asset that kind of pops up and we got to resolve and deal with it, there's money that you hold aside. But everybody agrees to everything, including the money you're holding aside. What you want done is you want ultimately, as the trustee, to be released from your duties as trustee, and that's going to require that everybody agrees to it. So when I meet with people, 2 years after the fact, and they say, yeah, all the money's been handed out to my brothers and sisters, I did it really fast, it was like a year ago, and now all of a sudden I'm getting this notice. Well, there was something that wasn't done right. Did you get a tax ID number? Did you open a bank account? And it's like, no, and no. We just divided everything up and split it. Okay, that's one way to do it. But what about the accounting for the administrative fees and the taxes and all that stuff? And most people are kind of not catching on to that and thinking that before mom and dad passed away, they didn't have enough income to file a tax return, so I'm not filing a return. Guys, you still have to close their estate. I mean, they've died, their social security number's got to be ended, and the last tax return of their of their life has to be filed. And then anytime there's money in the trust where there's an increase in the trust, like through earnings or through a rent payment or maybe a stock account growth or something, anything that's more than $400, $400, you have to report, you have to file a tax return. So most estates, unless the money is just sitting there in a zero earning account, are going to have to file a tax return for every year that trust is open. So some don't because they don't have any earnings at all. Some do because they have more than $400. I mean, it's like 1 month's rent from your rental or whatever. Well, a week or maybe 2 days income from your rentals. But that's the stuff you got to account for. So you want the trustee to be done, and you want everybody to agree. You want everybody to be happy with the money that they got. Okay, then you terminate the trusteeship when it's all over and you've waited the appropriate time. You have the holdback money that you had sitting out there, and that's all resolved. Then you get to terminate your trusteeship and officially close the trust and officially notify the IRS that trust is closed, the final return was filed, and that they can go ahead and close the tax ID number that you got for the trust and officially stop using it. Okay, that sounds like a wrap, right? That's exactly what we got to get done. And it doesn't matter if there's just two and they're beneficiaries that are the best, tightest, closest siblings ever. You still have to do these things because you're two separate legal entities. If you are the sole beneficiary of the trust, I understand you can waive a lot of this stuff. You can waive the accounting, you can waive the holdback, because it's all going to come back to you anyway. It's all going to be your problem. It's all going to be everything that you owe or don't owe, and everything you get, it's all yours. However, you've got to keep in mind that the Department of Health Services may be entitled to reimbursement from the probatable estate, which may be zero, but at least you're going to notify them and notify creditors, so that if there's any spillover later from some random claim against the money that you're inheriting, at least you can cut those claims off so you don't have to worry about them on into the future. All right. So that's really what happens. The successor trustee's job is a big deal. It's nothing to be taken lightly when you're naming them, and it's nothing to be taken lightly if you are doing that job as the successor trustee. You got to get help doing it so that you can get it done right. You just don't want to mess it up. You don't want the beneficiaries to have any reason to try to pick away at your own share of the inheritance. Okay. Now, the next questions we're going to get are, okay, Gary, I got it. But I am questioning what's happening in this trust from my parents because I haven't heard for a long time. So you said my trustee is supposed to give me a report and they haven't. Now what do I do? And that's the good question. Now you've got to try to push the thing through by, normally I would say you're going to hire an attorney that's going to start writing letters that say, hey, your job under this section, whatever, of the probate code is to do the following. And that's kind of the one I like to do is like, hey, this is your job. Let me know if you need help because, it's like, you're not doing your job. What's going on? And if they're just not going to do it and saying, sorry, I'm done. I'm happy with what the results were. And you may not be, then you can go to the probate court to get some assistance to compel an accounting to figure out what happened to the money. You can do that. So that's if it's not being done. What about if you didn't get your inheritance and it's all closed up, then what? Well, hope you haven't waited too long because you're going to have to go to probate court again to try to get the court to figure out what exactly happened and what happened to your money. And the next question I get from quite a few people is, Gary, why is this taking so long? My parents had a trust. They did a complete estate plan. They paid good money for it. Why is it taking so long? I thought having a trust is going to make the process faster. First of all, you're right in thinking that having a trust will make the estate process faster. Exactly right. And that's going to depend on where the assets are and how fast the successor trustee moves it along. But you don't have all the 3-month waiting period, 4-month waiting period, 3-month waiting period. You don't have all these waiting periods that are actually mandated by statute in the probate court. So you're not going to have like an extra 6-month delay. So that's the thing. If you have a trust administration going on, it's going to take time because you still have to notify the creditors and publish the notification in a newspaper and notify the beneficiaries. But those are all like, that's 120-day stuff. So it shouldn't take super long and you should be able to move on it pretty quickly. Usually within about 3 months, you should be pretty much into this trust administration, accounting for things, getting ready to try to do distributions, figure out what everybody wants. And then by the year mark, you should be at least giving the direct beneficiaries, like if it says, I want $100 to go here and my bicycle to go there, those things have to be done within at least a year. And then everything else is reasonable time, whatever that means. That means you're moving forward at a swift pace or as swift as you can with the snail crawl system. But what you're going to do is you're going to make sure that everything gets done right. And you're going to make sure that the trustee is serving right. And if there's a probate, that probate representative is doing right. Because you got to get through that and make sure everybody's doing their job. Because if they're not, you guys, you don't want your money to just evaporate. I would like to offer, if you have your favorite attorney that's going to help you through this, that's great. And if you don't, I would be happy to talk to you about working your case for you so that you can get your inheritance and get it done right. Or if you're a trustee, that you can get your inheritance distributed properly so you can just sleep again. And this stuff can give you nightmares. 855-500-TRUST, 855-500-TRUST. All right, tomorrow we are here with Ken Pecos. He's back. He's live and he'll be here tomorrow. Ken Pecos on the Word on Wealth. All right, go ahead, everybody. Have a good rest of your day. And we'll talk to you tomorrow here on the Word on Wealth.
Tell a friend about the Word on Wealth, featured since 1995. With financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs.